Intellectual capitalism, this is a word that is used. Intellectual capitalism is extremely important in our modern day economy. IPR is one of the pillars of business. Increasingly being recognized as vital asset of business, intellectual capitalism, IPR has obvious commercial benefits in enabling monopoly to be maintained. The logic of IPR is completely opposite to the monopolistic practices. I get a patent, I stop someone for 20 years across the world. Across the world. Though I get a patent here. But when I file a PCT application, I select various countries, file applications in those countries, I can stop. Dr. Reddy's got a patent and then it stopped entire South America from using a similar patent. 20 years, no one can touch you. Commercial value of IPR cannot be evaluated because of the intangibility and uniqueness of the property. I had an occasion to do a valuation for a software company that wanted to sell the company lock, stock and barrel to some British firm. They had about 15 trademarks which I had filed for, and then I got the registration. Just the trademarks was sold for almost 6 crores. Just the trademarks. Forget about the rest of the company being sold. Just the trademarks fetched them 6 crores. It is an intrinsic value. IPR is an intrinsic value that goes on increasing every day. You will not know what it is unless you valuate it. I always recommend to many of my clients, go on valuating your IPR. It is like knowing how much of deposit you have in your bank, what is the interest you are getting, how is your money growing. Not many companies do valuation at all. In fact, I came to know quite recently that some of the companies, in order to fill up their balance sheet, buy a patent which is already there and put it on their balance sheet and say, this is our. Engineering colleges are there. I always say this, in any engineering college I appear. There are 400 students in the engineering college, 500 students in the first year, 500 students pass out in the final year. All 500 of them do a project, right? All of them do a project, right? Or at least 2-3 people getting together, or 5 people getting together, there are 100 projects on hand for the college. Imagine if you file 100 patent applications. File 100 patent applications, kuch nahi hoga. File karo aap. 6,800 rupees if it is filed by an individual. Collect the fee right from the first year. Out of the 100, let us take 80 is thrown out. Prior art, non-obviousness, industrially not applicable. 20, they get a patent. Not just getting a patent is not the end of it. You need to commercialize your patent. How do you give it to someone and make money out of it? The other day day before yesterday I was telling, make money out of your invention. There is no point in having an invention and then saying, I have invented this. No, make money out of it. So commercialization. How do you commercialize it? Let us take out of the 20 granted patents, only 3 or 4 get commercialized. So what is the percentage? Out of the total filed applications, 3%. Is that not a value addition to your college? Value addition to the student? Is it not a plus point in the profile of the college? 10, 20 years, you will have at least 60 patents. And let me tell you, there are universities in US that don't get funded by the government. You know who funds them? The royalties from their inventions fund them. There are many research and development organizations in US which fund themselves sheerly out of the royalty that they garner from a granted patent and a patent that is commercialized. Think about it. When you go back to your college, think about it. Tell your students, be innovative. Not everyone is Einstein. Yesterday we all went to IIIT, right? You saw the gentleman showing that medical thing. What an invention. And that other gentleman who showed that black box, they are not rocket science, right? Are they rocket science? No. Very simple. A patent was granted for a jump clip. Patent was granted for a safety pin. Patent was granted for a stick note. Patent was also granted for a particular type of rubber band. You don't need to have a rocket science in place at all. It is just that spark of innovation That has to be caught at that time. Many people miss their innovation. Many people miss the fact that they have invented something new when they are doing research. That is why I always speak of innovation centers in colleges. Why should a college have an innovation center? They should have 2 or 3 heads of department. They should bring in all the inventions, put it in one thing, look at each invention and see how commercially viable it is. Can we file a patent? Can we make something out of it? I had been to one university one deemed university in South India, I will not name it. They have 87 doctorates as faculty, 87. And you know what is the number of patents they have? 2. Where are 87 doctorates? There is 2 patents. Then immediately we suggested an innovation center for them. We said, please set up an innovation center, try to do it. It is going to take some time. You want to reach the summit, you need to start at the base of the mountain and you need to trek the whole way till you reach the summit. By the end of 1.5 years, they had already filed 18 patents. You don't worry about patent being granted. Like the way yesterday I gave you an example of the wash basin. Patent pending, gave him a commercial mileage. Don't wait for the patent to be granted. File the application, get it published in the journal. Immediately start your commercial activity. Then, holder of the proprietary right has a freedom to exploit an invention commercially and get financial benefits or otherwise, and he can prevent others from exploiting the invention. These are the rights. I can stop anyone. I have a trademark. Section 28 of the Trademark Act says, stop anyone who uses similarly sounding mark, phonetically similar, deceptively similar, confusingly similar. If the trademark is such, stop him. You know Paradise Biryani. Heard about Paradise Biryani? I got about 11 injunctions for them across the country because someone else was using Paradise in different combinations. Hyderabad Paradise Biryani, Noida Paradise Biryani. I got registered marks, 23 registered marks I have. I said you cannot use it. So intellectual property gives you the right to monopolize. No other law in this country gives you the right to monopolize. In fact, there is a law against monopoly, MRTP. Now it is something else. Copyright, longest protection, lifetime of the author and 60 years after he dies. What is that movie? The Magic, that boy and Harry Potter. Who wrote it? The story? Jake. That person has earned money for the next 6 generations. Design, 15 years. Now I'll tell you how an intellectual property is there in, how many intellectual properties are there in a product. This phone is there. The name Samsung, right, is a trademark. Samsung is a trademark. The way how this phone looks, the shape of it, not the functionality, only the aesthetic feature, the beauty of it goes for a design. The source code that runs the programs in this qualifies for a copyright. The integrated circuits that are there inside the phone qualifies under the Integrated Circuits Designs Layout Act. And the source code, if it can be embedded onto a hardware, in the engineering language, it is called as system, right? System. System can be patented. In India, you don't get a patent for software per se. Even though you may have algorithms, you may have so many things, mathematical functions, you will never get a patent. You need to embed the software onto a hardware, make it look like a system and claim. So in just one product, how many intellectual properties are there? What property, what right? When it is a result of intellect in expression. When you say intellectual property, something born out of your intellect, only humans can do it. Can an animal do intellect, find out something? No. Inventions can only happen through humans. Even discoveries can happen through humans. Patent is given to a invention, not to a discovery. When the result of intellect is expression, property is copyright. I write a book, I draw a painting, I take out a movie. Expression. Idea form dichotomy. That is what we lawyers talk of. An idea that is reduced to a paper, then only copyright is not on the idea. Please Understand this. Copyright is not on the idea. Copyright is on the format. I can have an e-commerce program with 10 steps. Some other person can have e-commerce program with 6 steps. Both of us are entitled for copyright. Ramayana was written by multiple authors. All of them have a copyright. But you may ask me a question, sir, then what is copyright violation? Copyright violation is makhi to makhi copy. You know what is makhi to makhi? There was this exam going on. The guy in the front was writing and then suddenly a fly was writing his paper and the guy sitting behind him was copying him. Suddenly a fly was going and this fellow slapped the fly, that thing fell on the paper in a particular place. So the second guy was searching for a fly to put it at the same place. That's called a makhi to makhi copying. There's something called as plagiarism. You pick up part of the story from here, part of the story from there, part of this thing, put it, that is plagiarism. Plagiarism to a certain extent is tolerated and allowed. Copyright is not. Next, when result of intellect is invention, as I told you, there is a lot of difference between invention and discovery. Joseph Kepler, about 300 years or 400 years ago, said there are 9 planets. Oh, he was put, oh, good. What a discovery. What Joseph Kepler didn't understand is, in Tanjore, a district in South India, the entire Navagrahas are built in the form of the temple with the same latitude and longitude 2000 years ago. You know, there is the set of temples for, you know what Navagraha is, right? When you go into a temple, you find those 9. Exact position. Take a rope, take up this thing, tie it up to one place, pull it, put all of them placed within 60 kilometers. It takes 2 or 3 days for you to go to every place. It will be in the exact latitude and longitude. Not even 1 millimeter or this side, that side. Discovery. Something which is already existing, you want to tell the world. Invention. Not existing, you want to bring it to the world. When Ian Fleming left some breadcrumbs in his lab and then walked away, he came 3 days back, he found some water particles, that was penicillin. Then, the result of intellect is identity and quality. Property in a trademark. Origin of goods. You walk into a shop, you see blue bottles arranged on the shelf. You know it is Parachute coconut oil. You know it comes from Marico. You go pick it up and say, I am picking up a standard product. Origin of goods and quality of goods is trademark. Now I have been fighting a lot of trademark matters, infringement, patent infringement and all. There was this, I don't know if you saw the stores around the city called as More, Aditya Birla, right? Previously More in AP, undivided AP was Trinetra, T-R-A-N-E-T-H-R-A. I think T-H-R-A. One Smart Elect started Me, M-E-E, T-R-A-N-E, T-R-A. Me Trinetra. In Telugu, Me means yours. I had about 78 trademarks on different classifications for Trinetra, registered trademarks. I immediately had to file for a injunction and get an order. Trademark is indicative of the goods. It gives the consumer the idea that what he is picking up comes from a very standard house. There are violations happening. Rin is sold in villages as a run. I don't know how many of you have seen it. Rin, which is there, is sold as run. I is removed, U is put, same flash of red is there, same blue cover, everything. Identifying a product. Next, appearance, design. Sometimes design makes a very, very important effect on your eyes. I don't know how many of you know this brand called as Natural, which is an oil, that's being sold. Natural is a sunflower oil that's being sold. So those guys designed a bottle, container, 5 kg container, which was designed in such a way that the Indian housewife who is so very cost conscious can bring out the last drop of oil in that can onto the pan. That is the way how the bottle was designed. I filed for a design on that. I got the design. We found 3 different people in the country copying the exact thing, same yellow label, same shape, and selling the same sunflower oil in it. I filed a suit. I got a commissioner appointed. I conducted a raid. We went, seized 6,000 bottles in the factory. We didn't want to reuse the bottles, so I requested the court, let them be chopped into small, minute pieces, recycled. Court said yes. Design gives you a perception of the look, and design has nothing to do with functionality. Let me tell you, design is only the aesthetics, the look, beauty. I can have a cell phone today, file a design application, next day put grids on the cell phone and put a round tape around the cell phone, again file a design application for it. I can remove the cover, make the cover folded or buckled, again put it as a style, again I can get a design for it. Then, when result of intellect to be kept as confidential, trade secret. Trade secret is one of the oldest ways of having guarded an intellectual property in this country. Now, how many of you know the Hyderabad fish medicine, right? Put in the administrator. It's a trade secret. Coca-Cola, trade secret. Trade secret continues as long as it does not get onto the public domain. The moment it gets onto the public domain, its value is lost. Sometimes. But generally, the revelation is done because of a pilferage, not you being forced to reveal. Someone pilfers it and then puts it onto the thing, then the revelation is done. Now, I have a client in Coimbatore, what is that place where all these garments are manufactured? Tirupur. Yeah, you are from Salem, I know. Tirupur. This client manufactures products only for Yonex. He does not touch anyone else. I think it's called as Manchester of the East, right? Tirupur. Coimbatore is called as Manchester of the East. Very innovative people, highly industrial. Every house has got a forge behind in their compound. Anyway, this product was being sold only to Yonex. It was being sold to Yonex because that was being done according to Yonex specifications, and there is no intellectual property on that. Some of them even tell me, why should I file a patent? After 20 years it is on the public domain. Why should I do? I will not do it. Well, if you have the confidence of keeping it as a trade secret for 100 years, go ahead. Keep it as a trade secret for 100 years, exploit it as much as you can, make money out of it. You know what this family does? Before they weave, they ask all the employees to come out. They get into the factory, they have a particular this thing to be weaved, they set everything, close it, lock it. They weave about half a feet of cloth, then they allow all the employees to come. Family held secret. 3 sons, 3 daughters-in-law, father, mother. They manage the whole show. There is not even a board on their spinning mill, there is not even a board. But they make they make standard products for Yonex. In trademarks are there for so many things. One is for product, service. When I was invited by the Japanese patent office last July, I went there I was told that Japan registers for trademarks for gestures. So I was asking them, can I register for mudras in your country, right? Your dance mudras, Pataka, Ardha Pataka, Ardha Chandra, all those. Can I register for the mudras? It's a gesture. They said yes, you can always do it. Now, in all this, copyright can be universal. The moment I file a copyright application in India, under the Paris Convention, I get a right in 132 to 140 countries. Rest of them are all territorial in nature. Patent only in India. You want to file patent abroad, You need to file an application here, file a PCT, designate yourselves to various countries. I will tell you that with an example, you will understand it very easily. Designate it in various countries and proceed there. Patent PCT will give you an international status. There is nothing called as an international patent. If someone is telling you there is an international patent, he is bluffing. Patent is territorial in nature. Trademark, territorial in nature. Design, territorial in nature. Then copyright related rights, you can go through this. I will take you directly to the patents, which is very important. Yeah. It's an exclusive right granted to an invention. I have under 20 minutes, I will try completing it. Patent rights are territorial in nature, is granted for 20 years. Previously it was granted for 10 years. There is no renewal for a patent. Trademark can be renewed every 10 years. Design can be renewed only for 5 years. Copyright lifetime of the author, 6 years, it cannot be renewed. What is the criteria for a patent? When you say you want a patent, sir, I want a patent for mine. You should first see, have you complied with these 3 important things. One, invention means a new product or process involving an inventive step and capable of industrial application. In other words, it means novelty. It has to be novel. Just because I put a camera on a cell phone, it doesn't become a novelty. But I can get a patent for that particular hardware that connected the camera and the cell phone and made it work, but not for that idea itself. Then, inventive step means a feature of invention that involves technical advance as compared to the existing knowledge. There has to be a technical advancement as compared to the existing knowledge. Existing knowledge is a prior art. People who have already filed patents or products that are already there in the market is existing knowledge. Your inventive step has to be one step ahead of it. Then, having economic significance or both, knowledge, existing knowledge, both, that makes the invention not obvious to a person skilled in the art. Show this phone to someone who has been manufacturing. अरे ये क्या है? फोन को आप कैमरा लगा दिया और बोल रहे हो बड़ा इन्वेंशन कर दिया. Non obvious. Capable of industrial application. Must. I can't invent a time machine and seek for a patent for it. Is it industrially applicable? No. Always question yourself whether your invention qualifies for these 3. Inventions that are not patentable. This is also one more method of testing yourself whether your invention is patentable or not. Patent Act is the only act in the entire enactment system in India which says what is not patentable. It is a negative law. It says these things cannot be patented. Diamond versus Chakravarti, very famous case in US. I don't know how many of you have heard about it. But this gentleman, an Indian, developed algae that could eat away oil spills in the sea. He filed for a patent. The lower court said, will not give. Living organism. Will not give you the patent for it. He went in appeal. Supreme Court, he said, look, it is not a living organism. There was a human hand intervention in making it work for the purpose for which it is being invented. It could be algae, all right. But I taught the algae, I made the alterations inside the algae that enable the algae to eat away oil spills. Supreme Court gave the patent. And they also said anything under the sun is patentable. Anything, what a confidence. Anything under the sun is patentable. Now you have patents for oncomouse. You have patents for whatever is sheep and all those things. They are all. But again, granting patents there becomes an ethical issue, because can a patent be granted to something man-made which otherwise God is supposed to be doing? Yeah, oncomouse has got an industrial. They test it for your drugs and all that. No. Industrial application, not exactly in the thing of wheel and running and all that. Industrial application, let us put it, an application that is useful for mankind. Let me put it that way, because that is what is the definition given in the Act. Then, what are not patentable? Frivolous. Water as petrol without any mechanism. Ramayya from Tamil Nadu.